All right, I think we'll go ahead and get started. We'll still have a couple more people joining, so once everybody gets in the room, we'll get the doors closed and everything, but I don't want to delay any longer. So first off, welcome everybody. Thank you very much for taking time out of your day to come down here and join us for this super informative and super exciting program today. For those of you that don't know me, my name's Jared Bryant. I'm the office leader here for Faegre Drinker in Denver. And on behalf of the firm, I can really say that we're just excited and honored to continue to sponsor and work with the University of Colorado Law School in sponsoring the Supreme Court review. We're especially excited this year to be able to offer this as a hybrid program, both with an in-person component. And I understand joining us remotely, and so welcome everybody that's joining us remotely. We have several hundred people that will be online watching. So both to those of you that were able to take time out of your day and come down here in person, as well as for those of you joining us remotely, welcome and thanks very much. Just a couple of brief housekeeping notes. We do also have a couple of extra conference rooms in room 34A as well as 34C that will be showing the presentation remotely just as spillover space or breakout space if you need it. And really with that, I'm going to stop talking, but I want to introduce our moderator today, Professor Doug Spencer at the University of Colorado Law School. Professor Spencer is an election law specialist, and what a great time to be an election law specialist. Professor Spencer has joined us in Colorado about a year and a half ago, relocated from Chicago, has published quite a bit in the area in a number of journals, and I believe, if I get this correctly, you're PhD and JD from Berkeley, is that right? As well as an undergrad from Columbia, if I'm not mistaken. So with that, I'm going to turn it over to Professor Spencer, who's going to serve as our moderator for today's wonderful panel. Obviously, if anyone has questions, there will be time for Q&A. And again, just thanks everybody for making time out of your day. With that, I'll turn it over to Professor Spencer.
Thank you, Jared. Thanks to Faegre Drinker for hosting this event. It's absolutely wonderful to be back here in person, to see everybody. As I return to conferences and events happening in person, I can't explain just how exciting it is to be around people and to feel this energy. And so really appreciate you coming down and participating in this event. We welcome those of you who are joining us virtually as well. After the panelists provide some background about some of the cases from this last term, there'll be a chance for Q&A. And if you are watching remotely and you'd like, at the bottom of your screen, there's a Q&A function, which we're all, I hope, familiar with by now. And I'll be monitoring that. We'll be able to feed some questions to our panelists. And also, we'll be looking for participation from people in this room. There's a microphone, so we could pass that around so that people can hear your question when that comes. So we are at the 11th annual Colorado Law U.S. Supreme Court Review event, and how far we've come. I would like to extend a hello and a well wishes to you from our wonderful Dean, Lolita Buckner-Innes, who's the Dean of the CU Law School, who's unable to be here today, but wanted to send along her wishes, and she looks forward to seeing all of you at future events. I'm thrilled to see many of you. We have CU alumni, students, faculty, staff, friends, member of the legal community, and then people more generally who are here just locally and interested in some of these topics to benefit from the expertise that we have on this panel today. I'd like to thank our panelists today who have prepared a few thoughts about some of the cases that they were watching closely. Jennifer Hendricks is Professor of Law, co-director of the Juvenile and Family Law Program at CU Boulder. Eric Olson is the Solicitor General for the state of Colorado. Helen Norton, University Distinguished Professor at CU Boulder. That's a very high honor and rank. And Mark Taticchi, who's a partner here at Faegre Drinker, Biddle, and Reath. Bios for each of the panelists are available to you in the programs that were circulated before. If you're interested in learning more, there are sheets on the table in front of you with a URL, cu.law/program, or a QR code that you can use your phone to access that program and to see more information about each of our panelists and what they've done in their remarkable stories. From free speech to the Second Amendment to COVID mandates to arbitration, religious freedom, reproductive rights, this has been a term like no other. There was even an opinion, a draft opinion that was leaked 16 to 18 weeks before we saw its final version, which as it turned out wasn't that different, which may tell us something about how the court operates. One trend that we've observed this term, and maybe over time recently, is that the court is hearing fewer cases, it's taking longer to publish its opinions, and those opinions are lengthier. The Dobbs opinion, for example, was the third longest opinion published since 1946. So a lot of words being spilled. All of this speaks to a court, perhaps, that is more fractured. We're seeing more dissents published, perhaps less collegial. Public opinion of the court is dropping and is at historic lows. Just 25% of Americans say that they have confidence in the court, and that includes 39% of Republicans. The job approval for the court, according to Gallup, dropped below 50% for the first time since Gallup started tracking this, and it dropped quite a bit to 40%. So in addition to learning about some of these cases that have come up, some of the legal arguments that were made, some of the implications of the cases that we just saw this last term, I'm hoping that we'll think a little bit about what could it be about the way these cases are being decided or the cases that are being chosen that might be leading to some of these trends that we're seeing, more dissents and lower public approval. So with that, I'll stop talking and I want to turn the time over to Professor Hendricks.
Great, thank you, Doug. I'm going to turn on my little timer here. So my job today is to talk about Dobbs versus Jackson Women's Health. Regardless of what area of law you practice in, you probably already know more about that decision than most decisions that come down from the Supreme Court. I'm assuming everyone knows the holding. So my plan here is really to highlight the one thing that was most striking and upsetting about the opinion from a doctrinal perspective for me, and then try to leave as much time as I can for topics that people might be interested in talking about related to the decision, from other doctrinal aspects to some of the effects and concerns that we have going on here in Colorado going forward. I'm happy to talk about any of that.
Will you pull your mic a little closer? They're saying I have a little hard time.
Yeah. Is that better? I can be louder too. I can talk pretty loud. Okay. All right. So as you know, the Supreme Court in Dobbs overruled Roe versus Wade, which in 1973 had recognized the constitutional right to abortion under the 14th Amendment. That was reaffirmed several times, most notably in Casey in 1992, where after some last minute deal making, it was reaffirmed again. In Roe and Casey, and in most other cases dealing, not all, but most other cases dealing with fundamental rights, the courts have used a two-step analysis for determining when a fundamental right under the 14th Amendment has been infringed. The first step is to ask whether the law in question infringes on a protected sphere of liberty. If yes, then the second step is to ask whether the state has a strong enough interest to justify infringing on that protected sphere. So heightened scrutiny of some kind, whether we call that strict or intermediate or various other versions like undue burden, but some kind of heightened scrutiny because it infringes on a protected sphere of liberty. If it's not a protected sphere, right, if it's not a fundamental right, then the second question is just whether there's a rational basis for the law, which traditionally boils down to whether you can defend it with a straight face, right, and come up with a reason for it, which is really easy for me right now because you can't even see. All right, so Roe, of course, held that the decision to terminate a pregnancy was within the protected sphere of liberty. And then for the second step, it held that the state's interest in what the court called the potential life of the fetus was sufficient to justify banning abortion after the second trimester, approximately the point of viability. And Casey reaffirmed that structure. Abortion could be banned after viability, but added that it could be much more extensively regulated even before viability. Okay, so same basic structure, but a stronger state interest in regulation. I want to break those down a little more. I know I'm like living in the past here, but what I want to emphasize is it's the choice that the Dobbs court had before it when it came to how it was going to overrule Roe, because we all knew they were going to, right? It was a question of how, and I want to emphasize what the choice was and which option they chose. So if you start in that first step of the fundamental rights analysis, does the decision to terminate a pregnancy fall within the protected sphere of liberty, that's a question about bodily integrity and about reproduction. And it should have been, even in Roe, an extraordinarily easy question. The only reason it was hard in Roe was that the justices weren't in the habit of thinking of women as the kind of people who have those kinds of rights. But they got there anyway because the answer was so overdetermined by the law that existed even at the time with regard to liberty. It was overdetermined because abortion sits at the intersection of the two most well-established spheres of personal liberty under the 14th Amendment. If you made a Venn diagram of sort of family privacy and bodily integrity, abortion sits at the intersection of them. And I just checked my time, so I'm going to skip a little bit about that. And just say that those two rights, the rights to control over personal family decisions involving children and intimacy, and the right to bodily integrity, were both very well established by the time of Roe. And that's why I say it should have been an easy decision to say, yes, this is a protected sphere of liberty. The harder question in Roe was the way to give the claimed state interest regarding the potential life of the fetus. So even though the Supreme Court seemed to think the first question was really hard, the real hard question that didn't spend very much time on in Roe was the state interest and whether or why it justified the infringement into the protected sphere of liberty. In Roe, however, the court did cite two precedents that supported that infringement. And would justify regulation and restriction of abortion. The first one was Jacobson versus Massachusetts, which was the 1905 smallpox vaccination case, holding that the state interest could justify a bodily intrusion in order to stem the spread of infectious disease. That provides some support, right, for restricting abortion, but it doesn't do a whole lot because the infringement is so much smaller, right? The infringement on bodily integrity of getting a vaccine versus forced childbirth are really just on a different scale. So the second case that the court leaned on in Roe was Buck versus Bell as justification for intruding on the body in a way that affected reproduction. You may remember Buck versus Bell from law school, from your con law class, as the 3 generations of imbeciles are enough case. It was the case in which the Supreme Court, that was Justice Holmes commenting on why it was legitimate for the state of Virginia to forcibly sterilize Carrie Buck because it deemed her unfit to reproduce. So that precedent that the state, if it doesn't want the potential life that might come out of you, it can sterilize you. If it wants the potential life that might come out of you, it can prohibit abortion. Those were the precedents for the state interest in Roe. Okay. So that brings us to the choice that the Supreme Court faced in Dobbs. So done with the past. The question of how to overrule Roe, the easy way to overrule Roe, the obvious way to overrule it was to say that in Roe, the Supreme Court had underweighted the state interest, right? It had not given sufficient respect for the state's interest in the potential life of the fetus. And that interest is in fact compelling throughout pregnancy or at whatever stage of conception the court is interested in. But the easy, obvious way to overrule Roe would be to say that Roe didn't take sufficient account of that state interest, and it's so weighty that the state should be able to ban abortion. That would have made sense in several ways. One is it would have been consistent with the political narrative that has gotten us here, which has always claimed to be about the potential life of the fetus, not about, say, for example, making women second-class citizens who don't have control over their bodies. Okay, so that has always been the narrative. Second, it would have given the state the power to prohibit abortion without giving it more sweeping power over reproduction in general, right? So if the court had taken that path and said, well, it's the potential life that was underweighted in Roe, it could have overruled Roe while also repudiating Buck versus Bell, right? And repudiating forced sterilization, forced abortion, things like that. So it would have been a useful path in that way. And more generally, that path to overruling Roe would have allowed the court to do what in several places in Dobbs it claimed to be doing, which was to just excise the right to abortion out of the whole sort of constitutional fabric of constitutional rights without unraveling the rest of it. right? It would have been able to say, it's just because this compelling interest needs to be taken into account. So this doesn't affect same-sex marriage, it doesn't affect the right to contraception, right? All those other things that people are now worried about. Why are we worried about them? Because that's not what Dobbs did, right? It did not excise the right to abortion from the fabric of fundamental rights by holding that the state interest in the fetus had been underweighted. Instead, it much more explicitly and openly relegated pregnant women to second-class citizenship by holding that they simply don't have a protected sphere of liberty over control over their pregnancy, and that the state can regulate them how it likes, subject only to rational basis review. In the key paragraph, the court said, Roe and Casey struck a balance between the woman and the fetus, okay? Which is true, right? They did. Dobbs says the state gets to strike the balance, and it can strike it however it wants, right, in any rational way. So pregnant women, in other words, don't get to have control over their bodies. They don't have a protected sphere. And in case there's any doubt about what kind of balance the states are going to strike, I know we've seen many, many examples over the last 5 or 6 weeks that it's been. The most recent is that when HHS issued a reminder to hospitals that they are required to provide emergency treatment to people who are bleeding on their doorsteps, that includes abortion when it is medically necessary. And the state of Texas has responded with a lawsuit that accuses HHS of turning every emergency room in the country into a walk-in abortion clinic. So that's how Texas is striking the balance between the pregnant woman and the fetus when her life is in danger that way. So the main justification in Dobbs for this holding that there's no protected sphere of liberty around the right to terminate a pregnancy, I'm not going to go into because I'm guessing this, you've probably seen a fair amount of this in the media. It's all this sort of pseudo-historical analysis that the court claims is an interpretive theory called originalism. But I do want to make one point about that particular method of interpretation, which requires that fundamental rights be defined according to the opinions of basically ancient common law judges like William Blackstone. By choosing that method, you have determined in advance that women's bodily integrity is not going to be protected because it wasn't then. Right? If the scope of fundamental rights is determined according to a period of time when women were second-class citizens, then that's what you're going to have. Okay. At various points in the opinion, when the court sort of needed a rhetorical crutch, it did say, oh, but abortion is different. These other rights won't be affected because of the potential life. And I do think in the future, those sort of throwaway lines will be useful to justices who want to go one way or the other on which fundamental rights we're going to keep or not. But the logic of the opinion is very much in the other direction, right? The logic of opinion undermines the foundation of all the 20th century modern fundamental rights that the court has recognized under the 14th Amendment. And in adopting rational basis review for regulations of abortion, the Supreme Court already abandoned the idea that the only state interest that is at work here is preserving the life of the fetus, because it said rational basis applies. That means any legitimate state interest. And it listed several examples, some of which, like choosing the method of abortion, have nothing to do with the preservation of fetal life. So they have already authorized creativity by states in coming up with state interests that might justify regulation. So the one encouraging thing that I want to say about this opinion is that it is intellectually incoherent, and it will be fairly easy to pick and choose. That's good and bad. It's bad because letting them pick and choose isn't great, but they're going to do that anyway. I'm not making any predictions about what they're going to hold about same-sex marriage or related sort of rights to that one. I will make a prediction that with respect to the right to contraception is already lost because the anti-abortion movement's position is that most effective forms of contraception are actually abortifacients, and so will be banned, and that will be subject to rational basis review. So that's a grim prospect. But yeah, that's my positive take, is that things aren't predetermined because it's not really coherent. All right, so I think that's my time. I did have some notes about the law in Colorado, but I'll hold those and see.
You still have
people want. I know, but I'll save it. Too much to go into.
Thank you so much, Professor Hendricks. Solicitor Eric Olson, I've got this to pass to you. Thank you very much.
Thanks very much. And it's wonderful to be here with all of you again. This is a real highlight of my year to do this most years. So thanks again for having me here. I want to build on a little bit of what Professor Hendricks talked about, but focus more on sort of the one real rare sort of series of progressive wins at the court this past year, and talk about some advocacy lessons that all of us who don't necessarily spend all our time in front of the Supreme Court can learn from what made those successful. But before I do that, I want to talk a little bit more about something that Professor Hendricks talked about, which is really the Supreme Court talking about a lot of the questions are who decides. And we see that who decides question often framed as a procedural inquiry. In other words, the same standard applies as who decides. But I think what we've seen in the states after Dobbs is that who decides also brings a lot of substantive impact on the outcome of these decisions. And this term and over the past, this is the first full term with like the 6th justice supermajority, but focusing on, as between the Congress, President, and Supreme Court, I think we know from this Supreme Court how they view things, which is they decide everything, and that they've invented some doctrines or rehabilitated some doctrines, like the major questions doctrine, which does not appear in the Constitution, but nonetheless is used to limit the ability of the president and the executive agency to do things. There's a number of other sort of similar limitations that this court has embraced that really arrogate to the court itself the power to be the ultimate decision maker, and in so doing, because of the procedural process that the court uses, create significant uncertainty about the scope and availability of the congressional and presidential powers. Mark Lemley, who's a professor at Stanford, just came out with a paper last week talking about the Imperial Supreme Court, which really sets out sort of this thesis really well, and I would encourage you all to read it. Secondly, on the second dimension, sort of the states and federal government, and this is where I really want to build on what Professor Hendricks talks about, which is the court in allocating who decides among the states and the federal government often does so in a way that has significant impact on the actual lived experience of people who have to live under that decision. We just heard about Dobbs, but I'd ask to take a little bit a step of abstraction and talk about a constitutional right that is contested. Some people view it's not in the Constitution, other people say it's in the Constitution. The proponents of that right feel that it's rooted in liberty and freedom and sort of a core value of America. And the opponents of that right, their main complaint is that when that right is exercised, Americans die. And in the abortion context, that's very much how the debate is framed, but it also applies to Bruin, to the Second Amendment context, right, where you have the sort of expansive right that by definition, the more guns we have in our society, the more people will use it to die by suicide, and more innocent people will die. And it was striking to me that in Dobbs, they played such, as Professor Hendricks talked a lot about the impact of the potential life of the fetus as a basis, but they didn't excise it. They sort of use that to do much more damage. And that same concern occurs nowhere in Bruin, and there's sort of no parallel recognition. And so in the who decides question, what the court has done in Dobbs has basically said, you, the states, with no meaningful limit from any federal supervision, can do whatever you want here. As disruptive, the rational basis standard is so easy to meet as it can be. And in Bruin, they've done exactly the opposite. They said, you, the states, local governments, cannot do anything about this issue that you view as a serious public health threat and is really impactful of your schools, your communities, the way in which your constituents interact with each other. And so I'm not a law professor, so I sort of just throw my hands up and say, that sort of they're, it's just them getting the outcome they want using the tools they have. But with that framework, I want to talk a little bit about the decision between who decides on the court and arbitration front. And what we've seen recently is that most of this who decides question is really a proxy for corporations or individuals. That arbitration, although there's been some creative plaintiff firms that have used mass arbitration but by and large, it's seen the who decides question really isn't a procedural question. It's a, is there a remedy question, or is there a real remedy question? And so the court had 4 arbitration cases this term, which is above average. And I'll talk through each of them in particular at a high level, and then we'll go into some of the advocacy lessons from them. But the first one that they held was Badgerow, which basically said, most circuits have said there's a special rule that gets you into federal court if it's about arbitration. And here in Badgerow, the court said, no, the typical rules apply. You don't get a special pass to federal court. Most arbitration, when you were trying to enforce an award in court, which is really the only way you can get something out of arbitration, because otherwise it's a contract to give you something. You go to court to get what you need if the party won't comply. Here, the Supreme Court said, you know what? You can go to Louisiana State Court to enforce your award, even though Louisiana State Court is much more solicitous of claims of being fraudulently induced into the arbitration contract. It will give employees more ability to question the merits of the underlying arbitration. The court said, that's fine. You plaintiffs can go to state court. You don't have to go to federal court. So that was a big win for the sort of progressive folks in terms of allowing a meaningful check on some of the abuses of arbitration. The next case was Morgan. This is the case about a Taco Bell franchisee where they filed the employee wasn't paid overtime was the claim, filed a class action lawsuit. The Taco Bell franchise thought that they could get class-wide relief in their favor by letting this lawsuit play out. They'd win in class action. And then not only would they foreclose the ability of that employee to get any remedy, but they would foreclose the ability of any employee in the class to get any remedy. Well, their prediction wasn't quite right. And after a little over a year, they realized they actually might lose the class action. So they ran to court and said, oh, we have this arbitration agreement. We have to go arbitrate, can't be in court. And most circuits had a rule that said, hey, there's a special provision. You can always invoke your arbitration provision. There's no waiver, or the waiver, you have to show prejudice. It's really hard to show. And the court said, actually, no, that the right to arbitrate is just like any other contractual right, and you can waive it. And it's sort of the knowing and voluntary waiver of a right, and you're done. And so that, not only in that case, allowed for the employee to likely recover on a class-wide basis for overtime violations, which is one of the things that arbitration is used to prevent, but also made it much easier going forward for employees to get out of arbitration agreements if the company doesn't aggressively assert the waiver right, and it prevents gamesmanship by companies. The third arbitration case was Southwest Airlines, where there's an exception for transportation workers cannot be forced to arbitrate their employment claims. And the question is, what does a transportation worker cover? Southwest Airlines claimed that it covered people who are flying or driving things in between states, very narrow. And the court here, this was a case, the case was about a ramp supervisor at Southwest Airlines who was largely supervising, but sometimes helping load luggage onto the bottom of planes, but stayed in one place, never went across the state line. And the court said, you're covered. 8-1, that person cannot be forced to arbitrate. So it was a victory for sort of the employees because they expansively interpreted the exception of the Arbitration Act. And then the fourth case was Viking River Cruises, where California has what's called the Private Attorney General Act, where they, similar to what Texas did in Senate Bill 8, but they basically say, we are going to empower residents of California to enforce our laws and collect our penalties when you have a company that's violating the laws. And the Viking River Cruises arbitration agreement said, you have to arbitrate your disputes. And by the way, you can't bring any of these private attorney general actions in your arbitration. And the court said that that was permitted, that you can force the waiver of these sort of state private attorney general causes of action in arbitration. That was really the one loss for the folks representing employees against, the man, if you will, in these cases. And I was really struck because there was really no other part of the court's term this year where sort of the underdog won. Right, it was sort of devastating on so many fronts. So we're going to hear about some more in terms of some of these decisions. And I went and looked really closely at like what it was about these decisions that sort of led to this outcome. And there is no grand theory, or the best grand theory I could come up with, and Helen's heard me say this a few times, is that the court evidently had sort of a budget for mayhem this year that they exhausted in other cases and decided they weren't going to spend any of that capital here. But there's no coherent doctrinal reason that I can see why this came out the way it did. But when you look at the arguments of counsel, it helps that these aren't, super front page, hot button issues, but nonetheless, each of the counsel in the three wins did something that was worth noting and sharing that all of us can learn from. So again, I just color code the blue are the progressive wins and the reds are the losses. But in Badgerow, I was really impressed with Dan Geiser was the counsel of record. He's part-time here in Denver at Hayes and Boone, part-time in Texas. And he was a petitioner. And when you're the petitioner in the Supreme Court, you get 13,000 words to make your case. And Dan said, this is a really important case, really big deal. I'm going to use 7,000 words, right? His brief was basically half the length of what it could be because he focused on his two key arguments and let the other ones go. And we have a brief due in the Supreme Court next week. We are not going to be at 7,000 words. We're like 18,000 words right now. So, it's not a lesson for all times and all places, but in a high stakes case, to have the courage to say, hey, I don't need everything, is a reminder to all of us that do what you need, not what you can. In Morgan, this is a Taco Bell case. It's a hard question because you have the Federal Arbitration Act saying arbitration's favored, all this stuff. A lot of circuit courts have said there's a special rule for waiver. A lot have said they haven't. I mean, it's a real circuit split case. Paul Clement represented Taco Bell in this case, and he's argued 100 cases at the Supreme Court, really well-known advocate, but he has one speed, which is, I am right and you are a moron, is how he sort of presents his case every time, right? And so this is how, in this hard case where the circuits were divided, sort of he opens his brief with the court, basically attacking the plaintiff personally and using fanciful language. One can imagine a punitive rule being imposed by hypothetical act, right? It was a really hard, he lost 8-1, right, on this. And when you, I think, pretend that hard cases are easy, you really do a disservice to both yourself and helping the court do what you can, reach the result that they want to reach, which is to get a hard case decided correctly. And then the flip side is, in Southwest Airlines, it was argued by Jennifer Bennett, who's a partner at Gupta Wessler in San Francisco. It was only her second Supreme Court argument, and it is by a mile one of the best Supreme Court arguments I've ever listened to or read. She was exceptional in so many ways, and two things she did that were really, I thought, well done, was she got really hard questions about her case, and she said, that's hard, right? Here's why I think I'm probably right? But really gained so much credibility with the court and was viewed as someone who was helping the court figure out this hard question as a trusted advocate, rather than preaching to the court about what they should be done. She did it again in another question from Justice Kagan, and say, hey, the second thing that Jennifer Bennett did really well was she knew the record cold, and here went on to say it happened in 1972, and here's how they handled it. It happened in 1984, and here's how they handled it. But really knew her stuff incredibly well, to the point where, and this was one of the more remarkable exchanges in the argument. Justice Alito has a reputation of being a real, well, let's just say he does not approach oral argument with a customer service mindset, right? he is sort of a jerk and snarky and try to catch you in traps. And even he was just like, hey, so tell us what you think we should do, right? And then her answer here was quintessential, extraordinary answer, which is 3 short sentences, boom, 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 done, right? She knew what was coming. She knew how to get her answer across really well, and had turned someone like Justice Alito, who's normally looking to score points, into him saying, well, what should we do here? And if you can turn a judge into that, you've done your job. So that's the brief glimmer of hope we're gonna have today about some takeaway lessons that we can learn from this past term. Happy to talk about any of these or the relationship in the time for Q&A, but I'll turn it over to Professor Norton. Yeah.
Good afternoon. It's great to see you all. I'm going to talk about 2 religion cases where the court continued its contraction of the Establishment Clause, of the scope of the Establishment Clause, and then I'm going to talk about the Second Amendment case, where the court extended its insistence that historical analysis is the only way to solve certain constitutional problems. So I'll start with Carson versus Macon. This is a case that revisits long-standing controversies over whether and when the Constitution permits or instead prohibits the government from funding religious institutions or religious activities. Now, the Constitution, of course, the First Amendment, a lot going on in the First Amendment: speech, press, assembly, petition, 2 religion clauses. The Establishment Clause, the government can't enact laws respecting the establishment of religion, and the Free Exercise Clause. The government can't prohibit the free exercise of religion. Now, you might summarize or understand these clauses to mean that the Establishment Clause prevents the government from sponsoring religion, and that the Free Exercise Clause prevents the government from interfering with religion. And it turns out that folks have different views about what it means to sponsor religion or instead interfering with religion. Number of possibilities for managing this tension that have emerged over the years. For much of the 20th century, the Establishment Clause was understood to prohibit the government from funding religious institutions, religious activities like religious education. But 20 years ago, the court said no. The Establishment Clause permits the government, states or local governments, to choose to provide vouchers for parents to pay for tuition at religious school once that's part of a state or local government program that supports private schools, both secular and sectarian. So the court has held for 20 years that the Establishment Clause permits states to choose to provide tuition support for private religious schools alongside private secular schools. Now, in Carson versus Macon, the question is now whether or not the Free Exercise Clause requires the government to fund religious schools alongside private secular schools. And there are 6-3 court held that the Free Exercise Clause does require, here the state of Maine, to provide funding for religious schools when it funds secular private schools. And in so holding, it rejected Maine's separation of church and state concerns about using state funds to fund religious education. Maine had a program that provided tuition assistance, in other words, financial support, for families who live in school districts that don't have a high school of their own. And it turns out this is a big deal. Maine is the most rural of all the states. So this is a lot of school districts and this is a lot of families. And under Maine's program, parents in school districts without a public high school, they identify the high school they'd like their kids to attend. That could be a public high school in some other district, or that could be a private school anywhere. And the program provided the government, under the program, the government provided tuition support for attendance at private high schools, so long as 2 things were met. First, the private high school had to be accredited, which required certain curricular requirements. And second, the school could not be sectarian. In other words, it could not be a school that promoted or taught religion. So some parents who sought tuition support to send their kids to religious schools, but were denied under this program, brought a Free Exercise Clause claim. They said Maine is discriminating on the basis of religion. It's violating the Free Exercise Clause. And Maine argued that it had an important interest in preserving the separation of church and state, that the religion clauses should be understood to permit it, if it so chose, not to use taxpayer funds, not to use public money to teach and promote religious practice. And a 6-3 majority found that Maine's refusal to provide financial support for religious schools as part of this program was discrimination on the basis of religion, that it triggered strict scrutiny, and that Maine's interest in preserving the separation of church and state was not a compelling interest. So it failed strict scrutiny. Now, before Carson versus Macon, the court's precedent permitted, but didn't require states to include religious schools in these programs. So it left the choice up to the states. Now that's no longer the case. The court now understands the free exercise clause to require states to include religious schools when it funds private secular schools. Justice Sotomayor disagreed. In her dissent, she stated, quote, "The court now leads us to a place where the separation of church and state becomes a constitutional violation." And for similar reasons, Justice Breyer in his dissent asserted that the majority had largely read the Establishment Clause out of the Constitution, even though the Establishment Clause is the first of 6 express clauses in the First Amendment. Justice Breyer understands the religion clauses as that the whole idea, he thinks, is about preventing religious strife, right? When you think about the religious strife that occurred in Europe before many of the folks who first sailed across the sea to start communities in Massachusetts and Virginia and elsewhere. And he saw Maine's reluctance to directly fund teaching and promotion of religion as seeking to prevent that sort of religious strife, under the concern that lots of religions are not large enough to have private schools of their own. They might feel excluded and alienated. Taxpayers may be unhappy at funding the promotion of religious beliefs with which they disagree. So we see these sorts of tensions between the Free Exercise Clause and the Establishment Clause in another case, Kennedy versus Bremerton School District. Same 6-3 majority is again very quick to see Free Exercise Clause violations and very slow to credit Establishment Clause concerns. This case involved a football coach at a public high school who was disciplined, eventually terminated for his post-game prayers at midfield. The majority and the dissent disagree about the facts, and thus this disagreement also drives their disagreement about how to frame and resolve the legal issues. Justice Gorsuch, writing for the majority, describes the facts as involving a coach who offered a quiet, private prayer at midfield of thanks. Writing for the dissent, Justice Mayor took issue with Justice Gorsuch's description. She included in her dissent photos of the coach leading dozens of players in prayer at midfield, and she described this as a highly public display, quote, where a school official engaged in a tradition of leading prayer and ministering religion to students as the public watched. Again, those different framings of the facts lead to very different conclusions about the strength of the school's Establishment Clause concerns. Mr. Kennedy, the coach, brought both a Free Speech Clause claim and a Free Exercise Clause claim. Those have different doctrinal analysis. The long story short is that under either of those claims, we've got to assess at some point the weight of the school's interest in avoiding Establishment Clause violations. The majority found no Establishment Clause concerns presented by the facts of this case, so found that the school's discipline of the coach was unjustified under either claim. And most of the attention surrounding this case has focused on the majority's very narrow view of the Establishment Clause. And among other things, here, the court overruled Lemon versus Kurtzman, which is a 50-year-old case for assessing Establishment Clause claims. And this has several prongs. It looks to the government's purpose when it acts with respect to religion. It looks to the effects of the government's action with respect to religion. And it looks to whether or not the government is entangling itself with religion. And over the years, the court has developed several approaches for implementing Lemon, for making it work in action. Non-coercion analysis, which is the last of these bullets on the bottom of the page, asks whether or not the government's action has the effect of coercing religious practice. In other words, does it coerce, for example, folks to pray when they don't want to pray? And this approach understands the Establishment Clause is primarily about individual autonomy, about folks' freedom to choose whether and when to engage in religious practice. Everybody on the court, then and now, agrees that the government violates the Establishment Clause when it coerces religious practice. But justices then and now disagree about how quick or how slow we should be to see the government's coercion. And in this case, the majority saw no coercive potential in the coach's prayer. It distinguished earlier cases where the court had found school-sponsored prayer to be coercive, cases where a school incorporated prayer into a graduation ceremony, case where the school broadcast prayer over the public address system before a football game where students were required to attend. The majority found those facts distinguishable from this case. It described this case as involving the coach's prayer in this case as private, personal, and voluntary. The dissent disagreed, arguing that the coach's prayers had great coercive potential, emphasizing schools' coercive authority over students, young people's susceptibility to social pressure by peers, by coaches, by teachers, and expressed concern about the fact that student athletes might perceive their playing time or other advantages to turn in part on whether or not they pleased the court. So that's coercion analysis. It remains in play, but the majority is very slow to see it, very slow to see the government's coercion. The majority also went on to entirely reject non-endorsement analysis. This is another approach that the court had used to implement Lemon. This approach was developed by Justice O'Connor in the 1980s, and it asked whether a reasonable observer would understand the government to be endorsing religion in ways that communicate to non-believers or to religious minorities that they're outsiders, that they're second-class citizens. And this understands the Establishment Clause to be not only about individual autonomy, for sure, but also to be about equality and inclusiveness. And here, the majority overruled those cases, arguing that non-endorsement analysis has no basis in constitutional text or history. So no longer will the court assess whether or not the government is impermissibly endorsing religion. Instead, it's going to assess Establishment Clause claims by reference to, quote, historical practices and understandings. So the majority announced historical analysis as the key to Establishment Clause claims going forward. The historical analysis that announced in Dobbs, the historical analysis announced in Bruin, Second Amendment case, but at least in this particular case, it didn't provide any detail or guidance about how to engage in that analysis. So long story short, the majority's decision in this case dramatically shrinks the scope of the Establishment Clause. First, by narrowing coercion analysis, and second, by abandoning non-endorsement analysis. Okay, finally, moving from the First Amendment to the Second Amendment. And a thread, a connection between the case I just discussed, Kennedy versus Bremerton, and New York State Rifle and Pistol versus Bruin, and also with Dobbs, is the majority's insistence that historical analysis is the only way to think about a growing number of constitutional problems. Now, in Bruin, the parties agreed that the Second Amendment, as incorporated by the 14th Amendment, protects the right of ordinary law-abiding citizens to carry handguns in public for self-defense outside of the home. Heller and McDonald established the right to possess handguns inside the home. This is outside the home, carrying handguns in public areas. And the question here is whether New York violates that right when it requires those folks who want a license to carry a gun in public areas to show some special need for protection. The 6-3 majority here announces that the only way to answer this or any other Second Amendment problem is through historical analysis. Quote, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. And the majority says historical analysis is more legitimate and more administrable than asking judges to make difficult empirical judgments and cost-benefit analysis. So it rejected the application of, quote, any judge empowering interest balancing. And so for this reason, it rejected the intermediate scrutiny test that the courts of appeal had been using in Second Amendment cases up until this time. It then applied historical analysis, and it found no regulatory tradition of preventing law-abiding citizens with ordinary self-defense needs from carrying arms in public areas. Both parties, as you can imagine, offered lots of historical evidence. The majority found that some of New York's historical evidence was too old to shed light on this question, that some of New York's historical evidence was too recent to shed light on this question, that some was too limited or distinguishable. The dissent, in contrast, looked at the historical record and reached a different conclusion. It found support for a 700-year Anglo-American tradition of regulating the carrying of firearms in public. So among whatever you think about historical analysis, the majority's claim that it will make hard cases easy is inaccurate. Now, the dissent quarreled not only with the majority's application of historical analysis, but also with the majority's threshold insistence that historical analysis is the only way to think about these problems. And Justice Breyer's dissent identifies historical tradition to be one of multiple available tools for thinking about these sorts of constitutional problems, but not the only one, nor the best of them. So the dissent, among other things, would consider democratic self-governance, would consider pragmatism, would consider purpose as additional tools for thinking about the Second Amendment. In other words, tools that would permit legislatures to consider and respond to the dangers and consequences of gun violence of the sort that Eric talked about. This dissent also doubted courts' competence as historians and worried that this would place unusual pressure on lower courts to try to work through this analysis. So these, what does this mean for future gun control efforts? These are the possibilities that the Bruin majority specifically discusses, or that Justice Kavanaugh also discussed in his additional concurrence. I don't mean to suggest that these exhaust the possibilities. I'm just flagging those that were specifically discussed in the majority's opinion. Open to restrictions on gun possession by felons or the mentally ill. That was articulated in Heller. Open to the licensing regimes in Colorado and many other states, where you can get a license based on a general desire for self-defense, no special showing, but you might have to go through a background check to make sure that you are in fact a law-abiding citizen. You might have to go through a safety course. The majority signaled that should not be a problem, that you could find a lengthy historical tradition for those sorts of regulations. But the majority said there could be a problem though if you have to wait too long for your license, or if you have to pay too much for your license. And the majority also talked about longstanding historical tradition of regulating firearms in sensitive places, like legislatures, courtrooms, and polling places, and left open the possibility that maybe we can define the historical tradition in a way that allows us to add to that list of sensitive places. I look forward, I'm grateful for your patience, and I look forward to the discussion.
Thanks, Helen. Hi, everyone. So as you heard, I'm Mark Taticchi. I'm going to talk about some cases, 3 cases that talk about the limits of federal power and federal administrative authority. The 2 COVID vaccine mandate cases, and then the West Virginia versus EPA case, which talked about the federal Clean Power Plan. I think Eric foreshadowed this a little bit, talking about the major questions doctrine, because that figured heavily in 2 of these 3 cases. So we'll get into it and then talk about the broader implications at the end. So the first of these is Biden versus Missouri. This is one of the 2 COVID mandate cases. In this one, HHS required the employees of HHS or government-funded healthcare institutions to be vaccinated against COVID-19. And the question was whether that was permissible. This came up in a stay posture. That was something that was an interim rule was published in November of last year. It was then stayed. The 5th and 8th circuits, I believe, declined to lift that stay, and then the Supreme Court, on an expedited basis, considered whether it should stay those injunctions of this order. And as the slide notes, the court decided that yes, in fact, the federal government had this authority. It's a per curiam opinion, so we don't know who the author was, but it was 5. You could tell from the dissents that it was 5 justices in the majority. Separate dissents by Justices Thomas and Alito. Justice Thomas's dissent really focused more on the substance, saying that this is not a power that you can exercise. It's not authorized by the statute. And Justice Alito's was really a little bit more focused on the procedure, saying that you don't have the, you didn't use the appropriate procedural mechanism to get this as an interim final rule, as opposed to go through the normal notice and comment rulemaking.
Mark?
Yes.
Sorry, I don't know if maybe you could use Helen's mic. There's a few people on Zoom who said
I'm
they can't
sorry.
hear you. It's not,
Yeah, no.
just passing that message along. I don't know if that will help.
Is that any better?
I don't know. We'll see
Find
in a
out.
few
Okay, well,
seconds.
yeah, we'll see.
But thank you for.
Yeah, sure. So the majority's rationale was that that this is something that fits comfortably within the statutory text. The majority and the dissent have a bit of a quarrel about this, but the main authorizing statute says that HHS can and in fact must prescribe rules and require facilities to adopt rules that an infection prevention and control program. And that's what the majority relies on, and says that just like you can mandate washing hands and all sorts of things to manage the spread of infection in healthcare facilities, the government can require hospitals, especially given the vulnerable populations that often find themselves in these facilities, it can require them to be vaccinated to prevent the spread of COVID-19 within healthcare facilities. Justice Thomas notes in his dissent that 5 of the different kinds of facilities don't have an authorizing statute that requires the maintenance of these kinds of infection control mechanisms. The majority waves it off and says that that would be allowing the tail to wag the dog, and says, those are only a few % of the total population that are served by these facilities. So essentially no big deal, and just waves off the concern without really responding squarely on the merits of the textual analysis. So the second of the 3 cases is the NFIB versus OSHA. Now, this is the employer mandate case for large employers. This regulation by OSHA required employers with 100 or more workers to require their employees to be vaccinated. The catch, or one of the problems that the court had in this, was that there was an alternate procedure that was available. You could require a test and mask procedure if anyone declined to be vaccinated, but employers weren't required to offer that. It was an employer choice. It wasn't something that was truly an either-or requirement of the regulation. It was something that employers could choose at their election. The court said again in this one, again per curiam, again a 6-justice majority, that this rule was invalid. A lot of the action actually though comes in Justice Gorsuch's concurrence, which we'll talk about in a second, and then the dissent in this one written by Justice Breyer. And so this is really a clear statement rule case. This is where the major questions doctrine first really rears its head this term. The court said that if you're going to allow an agency to decide for itself something that is so significant, that has such significant impacts on such a large swath of the American population, we'd expect Congress to have actually said so in so many words. It's not something that we can read between the lines or read into a broad general grant of authority, but whenever Congress is going to speak, is going to confer this kind of authority, they're going to actually have to say so very clearly. And this is something that Justice Gorsuch again refers to in his concurrence as the major questions doctrine. The majority's problem is that, if you take this sort of view that anything that's a sort of public health problem or public safety problem that also happens to overlap with the workplace or can occur in the workplace, that is a slippery slope that then leads to federal regulation or federal mandates for any number of concerns that would entrench on police power. And so it sort of takes both a separation of powers and federalism angle here and says, when Congress wants to do this, it's going to have to speak very specifically to the problem. And again, Justice Gorsuch's concurrence is more interesting in some ways than the majority, because he really links this major questions doctrine also to the idea of the non-delegation doctrine, which is a broader, more constitutionally rooted doctrine that says, there are some things that Congress just can't delegate. There are limits to what Congress can assign to an agency or to some executive branch official to decide and do, and really seems to be drawing a line in the sand for Congress to say, you're going to have to really do your job. You're going to have to do it in the first instance. When you pass a statute, you're going to have to update your statutes over time. We're not going to do that job for you by allowing agencies to just interpret and reinterpret as years and decades go on to address new and divergent situations as they come up. You're really going to have to actually speak clearly to these new circumstances as they arise. And footnote, by the way, there are going to be some circumstances where we tell you, you can't do it at all. And you, Congress, are going to have to speak to all the minutiae directly. You're not going to be able to outsource it to an expert federal agency that has public health expertise or employment expertise. And again, the main benefit of agencies has the additional expertise and specialized knowledge that 535 elected officials in Congress decidedly lack. And so we'll talk the last of these, again, a major questions case, West Virginia versus EPA. This is the case about the Clean Power Plan. The Clean Power Plan is interesting because it was, again, everyone I think agrees it was a novel approach by the EPA to manage greenhouse gas and climate change, effectively requiring greenhouse gas intensive coal plants to subsidize the development of lower emissions power generation, whether that was through natural gas or clean, renewable energy sources. And so the fundamental question was whether the EPA had the authority to not just put in place use scrubbers, use better technology on your own plant, but actually could force power generation companies to move to subsidize the operations of their competitors, essentially, and eventually over the course of time shift the balance of the energy market in the United States away from coal and to other forms of power generation. And again, not surprisingly, in a 6th-justice opinion written by the chief, the court concludes that no, EPA did not have this authority. Again, this time the major questions doctrine moves from the concurrence expressly into the majority, and the chief says this is a major questions case. This is something that's very consequential. We're talking about fundamentally reorienting the U.S.'s energy industry. We're talking about picking winners and losers in that industry for generations to come. This is not something that's within the bailiwick of the EPA. You know, there may be other agencies that are better suited to make these kinds of determinations. The EPA even asked for special emergency funding because it lacked the expertise to do this, the court pointed out. And so it was not, you know, it was not something that you could read into its general grant of authority to manage these kinds of pollutants, the ability to reorient the economic structure of the energy industry in this way. The more interesting, I think, question here for the long-term sense, beyond the fact that this is for those who are concerned about greenhouse gas emissions and climate change and what the federal government can do to manage this on a national level. But for future cases, you know, the major questions doctrine is one that's seems like it's going to be recurring more and more, I think, as Eric was alluding to a little bit. And I think, you know, maybe this dovetails a little bit with one of the things Jennifer was saying too. It seems like the court puts the rabbit in the hat a little bit and says that, you know, well, the major questions doctrine is triggered in cases where we don't think Congress would have just delegated this authority in this way. But again, you sort of have already answered the question at that point, because if you're deciding whether to apply the doctrine based on whether you think Congress would have written the statute this way, you've already decided, because you're never going to say, well, the Congress probably wouldn't have written it this way, so let's look for an extra clear statement of intent that they did, because you've already answered it. And so it really looks like at the end of the day, you're at risk of this boiling down into something where it's justice's own preferences or their skepticism of agency decision-making that's going to be driving their application of this doctrine in future cases. You know, they really don't lay out in these cases anyway what the criteria are that they will apply, and you can't really just say, well, it's something of great public significance, because that's, you know, everything that, you know, any number of federal agencies do would fall into that category. So they're going to have to, I think, work very hard in future cases to make this appear at least as a legitimate administrable doctrine, and not something that's just going to come up every time there's a novel assertion of authority or an application of traditional authority to a new set of facts. And I guess the one last point I'll make is to tie this back to the Biden versus Missouri case. You know, why wasn't that a major questions doctrine? That wasn't something that was discussed in that opinion, but, you know, you can speculate that it just was a much narrower swath of people affected. If you're trying to look at this through a legitimate lens, you say, look, that was just something that was very squarely within HHS's traditional role. You traditionally can prescribe rules for healthcare facilities that are funded by the federal government. This is a rule for healthcare facilities funded by the federal government. There's at least a plausible connection to infectious disease management and control, which is something HHS typically does in those policies it requires hospitals and healthcare facilities to adopt. So there is more of a nexus there, but I think that, you know, the real answer, the one that's you're going to see, is the rule of thumb, or the gut rule that you're going to see in future cases is this a big case or not? Is this something that is a big deal or not? And that's when you're going to see the major question doctrine rolled out, and that's when you're going to see the court say, no, Congress needed to speak to this more specifically. And if Justice Gorsuch has his way, you know, as he flagged in his concurrence in the OSHA case, you're going to see some circumstances where the court's going to increasingly say the agency can't do this at all. Congress has to regulate it directly itself. The chief really seems on a campaign over the course of many years to shrink the scope of the federal administrative state. So he's probably there too. And so that's already 4. And so you're just looking for 5 at that point if you're Justice Gorsuch or someone else who's similarly motivated.
Inspiring. Thank you. Yeah, thank you so much to all of our panelists for these really nice summaries of these cases. Hopefully Many of you are familiar with these cases. You've been watching the term. If not, hopefully you've learned something new and thought about this in a new way, and maybe taken away some broad themes. I hope some positive themes, because I like to bring some sense that the law still matters and the court's doing good things that can help improve our world, but we've heard some ways in which maybe that's not the case. There was a question actually that came through here from Zoom, and if there's questions in the audience, please raise your hand and I will get to you. And I think I may walk a microphone around because I want to make sure that people can hear that. One of the themes that came through several of these cases, not all of them, but is this idea that the court's heavily focused on history. Rights that are deeply rooted in America's history and tradition, the history of the free exercise clause and gun rights. And the question says, with so many cases citing historical analysis as the only way to answer constitutional questions, how do lawmakers ever have an ability to write new laws with new solutions? Doesn't this analysis approach lead to absurd results? I realize we're all lawyers here and not legislators, but I think that the person asking the question is hoping you'll put on maybe a legislator hat. Or how are we innovative in this environment if this is what the court's going to do at every challenge in every way? And I just an open question for anybody who feels compelled to opine. All right, Professor Norton's got something.
I really appreciate the question. I've been thinking about it as well. And I guess one of the things that we have to think about, that I think about, is the way things are today are not the way they always have been, and the way things are today are not the way they always will be. And when you look at early cases in a series of cases, and I don't know where we are in this series of cases, but let's say we're early in the court's sort of thinking about history as the way to go. The early cases are not always the best cases, right? There's a learning curve and there's throat clearing and things like that. And I think there are many critiques of the court's reliance on historical analysis, right? It claims that it's more administrable. It's not, right? It's folks fighting about history. Claims that it's more legitimate. Read the dissent in Dobbs. It's not. Why should we be bound by the views of the ratifiers of the 14th Amendment, 1868, about the scope of reproductive rights when they did not include women? The court prefers this basically because they are afraid of judges. I mean, I think they're very quite clear that this is a choice that is motivated by distrust of judges. And the court and the majority talks about its disdain for judge empowering balancing tests. And so the court is saying, we want to have a baseline for decision making that will bind unaccountable judges. And this is what we've come up with, which is not the same as saying that this is a good rule, right? It's not saying that it's a quality rule. It's saying that we trust these decision makers more than we trust these decision makers. But when you think about constitutional law, right, it's all about the big picture purpose of constitutional law is coming up with a framework for a healthy democracy, which is why I appreciate this question and its focus on legislators. And ideally, if you were to take, I think, the best and most principled approach to history, right, if we were to try to make lemonade out of lemons, right, we would define the relevant regulatory tradition in a way that enables us to learn and grow from experience. That it enables policymakers, legislators, we the people, to learn and grow and develop. And a regulatory tradition that is generous enough to reward and not punish learning from experience is the one, I think, over time that courts should be privileging.
So I really like Helen's vision of what the use of history in jurisprudence would look like. And so as you gathered already, I'm fairly dismissive of originalism as an interpretive theory. I think it's had plenty of time to try to show that it can be useful, but that doesn't mean history is irrelevant. So I do like that vision of learning from history, and I think that could be a very positive one. But I would say, it's sort of in response to the question, that the court has left a great deal of room for legislators to work creatively to address social problems. It's just in a very one-sided way. So in Dobbs, right, it's the individual, like when I think of individual rights questions as separation of powers questions, right? There's like the federal government, the state government, or it's Congress, the courts, the executive, and then there's me, right? So fundamental rights questions are separation of powers between me and the state. What do I get to decide about my body? What does the state get to decide about my body? And what the Supreme Court said this term was that when it comes to my reproductive body, I have no rights unless I can justify them according to Matthew Hale, right? The witch hanging guy. But what it said in Bruin was the legislature has no power unless it can point to it as something it has done before. It's not, this court is not making the state justify its restrictions on abortion by showing that they are historically grounded and that abortion has always been restricted in this way, because it has not, right? This is another thing you may have seen a headline on. Benjamin Franklin had a recipe and instructions for abortion in like one of those almanacs he put out for people to keep around their house, like right along with how to clean your pots, right? Right? Black menses were a thing, right, at the time of the founding through the 19th century. So the court in Dobbs encouraged a lot of legislative creativity in finding ways to make sure that women perform their reproductive duties and conform to their gender roles. So it's not that the court doesn't want legislatures to look for solutions to problems. It's just I don't agree that the things it thinks are problems are problems. So I like the vision. I have a more beaten down sense of where we might be on the course to that vision.
I'll just add one more to that if I can. And what I feel like gets eliminated from the historical accounts so much of the time is just the historical understanding that at the time of the founding and framing, and even when the post-Civil War amendments were enacted, you didn't have state or local government able to, just as a practical matter, intrude so deeply into people's lives. The balance of state versus individual liberty was just so fundamentally different then. The scope of what a state could do was talking about, taxes and just making sure the roads were sufficiently, not potholed that you could roll a cart down the street. I mean, that was the extent of state government for a lot of places in 1789. And, the idea that the court sometimes says, well, unless there was a restriction, the state can do literally anything it can think of under its general police power, I think is sort of not sufficiently constrained by the historical understanding that most decision-making really was personal autonomy driven, personally family, community driven at the time, not something that rested with the state or even with a local government.
Carter, we've got a CU student, Carter Hilty.
I have a question. Oh, whoa. Okay. I'm curious because there were a lot of firsts, particularly Dobbs seemed like a sort of the court being willing to reassess doctrine from 50, 100 years ago. I'm curious if, in your view, this has established a very predictable course of decision making where they're always going to follow this sort of new ideological line they've established, or if they've sort of opened the door to all kinds of wacky reasoning and new ways of assessing these big problems.
I'll just jump in quickly and say that the court has, already granted cert on the independent state legislatures doctrine case for the election law experts, which is something that didn't have very many adherents. You can correct me if I'm wrong. We didn't have many adherents not before 1 or 2 election cycles ago, and is now on on the fast track to the Supreme Court, and already has some defenders among the 9. So I think yes, the re-examination of sort of what had been taken as fundamental accepted bedrock truth among Supreme Court practitioners and court watchers and scholars is I think going to be the norm for a while.
And I would just add more pragmatically that I think Mark Lemley lays this out well in his article. This court is going to do whatever it can until our institutions stop it in some ways. And there are lots of existing ways to stop it. Some members of the court are really focused on public perception and their authority. But I would just self-restraint is not an attribute that is widely shared on the court, nor is intellectual humility. And so I think that there's a real need to think about how you contextualize what the court is doing in our larger republic, and make sure that we're all using the tools that we have at our disposal to keep the least democratic branch of our government from taking more power for itself. But it's a real challenge. I mean, we have a case that Helen and I are working on in the fall at the court, and it's hard to, how do you argue in front of a court like this when there is no precedent, and you basically have to explain the mayhem that will result, and it's a real challenge, and it's a real uncertain time, and somewhat scary. But I do think there's opportunity to use existing tools, not just argument tools, but leverage tools we have to constrain some of the worst tendencies of the court. And as Helen mentioned, we're early on in this journey, and I think they're going to get it better. They recognize some of the imperfections, and things may improve even if we stay on this path.
Okay, you voiced an opinion or a view, Professor Hendricks, that Dobbs treats women as second-class citizens, but Roe was decided by a court that consisted of 9 unelected white men. And from reading Alito's opinion, the court appeared at least to be very concerned with reducing its power and returning power to the people and thereby women. In fact, Alito wrote, "Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Women are not without electoral or political power. So if we want women to have a voice, isn't it good and constitutionally correct, per Articles 1 and 3 of the Constitution, for the court to return the power to the states where women actually do have a say?"
So women actually have a say in the federal government as well. So yes, I believe in democratic politics. I believe in empowering women. Things like the independent state legislature doctrine are being readied to destroy that, for example, by greatly increasing the power of the states through the Senate, through the Electoral College, which are very anti-democratic institutions, and are one of the big problems in respecting fundamental rights. The ideological question of whether women should be second-class citizens, should be relegated to particular gender roles with regard to reproduction, is a one that has women and men on both sides of it. So there are plenty of women who do not believe that women should be sitting in chairs like this one, or that when they do, for example, on the Supreme Court, they should be using it to advance an ideology that prioritizes women's reproductive role and women's obligation to reproduce. And that is the origin of the abortion bans actually that we're dealing with now from the 19th century. The question of women's political power, though, raises another issue about the decision. There were quite a few passages in the Dobbs majority opinion extolling all of the wonderful rights that women have won, including electoral power, over the course of many decades. It was a requiem for intermediate scrutiny. That is a prediction that I will make for sex classifications, right? It was a repudiation of the discrete and insular minority, John Hart Eli rationale. I hope people remember all this, for heightened scrutiny for sex classifications. And was, to me, read as a first draft of opinion that says you're equal now, so no more scrutiny of sex classifications. If there's any type of regulation that warrants scrutiny of sex classifications, it is sex classifications with regard to reproductive biology. That is where sex inequality happens, is where men and women need different kinds of rights, whether that's a right against pregnancy discrimination in the workplace, rights to childbirth leave, that kind of thing, or the right to abortion. That's where women's inequality happens. And it is an ideological issue that is connected to much bigger ideologies about the role of the individual versus the state and versus the church that are what we are fighting about now. So I do not think any more than the fact that men have had lots of political power for a really long time means they don't need the First Amendment to protect them from the overbearing state for speech or religion or anything like that. The fact that women can vote now doesn't mean we don't need individual rights protected by an independent, but politically and democratically accountable judiciary.
I saw a hand over here in the far corner by the wall and then in the front. Thank you, Yesenia.
Just generally, what do you think of the possibility of stacking the court or impeaching any of these justices who maybe violated their obligations to speak truthfully when they were being confirmed?
Well, I'll just say something real quick, which is, I think a lot of the more novel exercises of checks and balances on the court that we have can be stifled by the court itself, right? And I certainly think that if there's an effort to use impeachment in a way that hasn't been used before, that this court will not let that happen, right? And so I think, candidly, the more effective ways of reining in the power of the institution is A, not to focus on individuals, because that gets everyone's back up, and B, Congress has the ability to defund the court. Congress has the ability to have justices serve for term limits in some way, shape, or form. Ways of taking away a lot of the resources that the court has right now as a way of bringing it back into line. But I think anything that goes after individuals is going to fail and make institutional change more difficult. Is sort of my view.
All right. I'll add something just to that. I don't mind going after individuals. However, I am against the impeachment argument for perjury during confirmation hearings, because I think that lets the Senate off the hook. Nobody said, I promise not to overrule Roe, right? They said Roe is settled law. That was a statement of fact. It wasn't a promise. It wasn't anything. And everyone knew it was bullshit. Right? Everyone knew the whole discussion was, including the people who voted to confirm them. So I think pretending that there was some deception going on about their views, maybe the public was deceived. But the guilt there, if the public was misled and deceived, was with the guilt lies with their elected representatives, especially in Maine.
Here in the front.
Hi, I'm a humanities professor, and so please forgive my lack of jargon in the asking of my question. I wanted to know if any of you would be comfortable commenting on the overturning of the Huerta Castro case in Oklahoma of indigenous, the extent of indigenous ability to self-regulate on their own lands and First Nation rights.
I'll just say it shows how much personnel matter on the court, and I think it also shows how much, I'll say this in a positive way, that when we have a court, and those of you who've been to this before, I work this in almost every year. So when we have a court that doesn't look at all like America, that has experiences that don't look anything like America, we get really out of touch decisions. And say what you will about, I have some very heavy criticism of Justice Gorsuch's approach to some doctrinal and constitutional issues, but his experience of actually being familiar with tribal concerns, of understanding the issues that arise, not just as a theoretical concern, but something that he has some experience with, I think is really illustrative of how he approaches those. And I think the absence of that experience from anyone else in the court really shows. And I think that if we had justices who had even more, it's kind of embarrassing to say, well, Justice Gorsuch bringing all this, weight and experience on tribal issues just because he lived in Colorado and kept his eyes moderately open, right? But he nonetheless brings that experience to it. So I think particularly on tribal issues, that having the firsthand experience where it's not some abstract theory of constitutional question, it's about real people wanting control over their own lives in real and meaningful ways, that you will see different outcomes, and that Justice Kavanaugh and Barrett do not share that same concern.
One more final question here in the middle. Yeah. Great.
Thank you. Do you think Justice Breyer, with his age, will consider stepping down in his term? I'm sorry, not Justice Breyer. No, but, I might be mistaking my justices. There was an older justice I was going to ask if he was going to step down, but I think I have it in the right. I did have a different question. If I can just transition instead, we'll just bypass that. Based on Mr. Taticchi's comments that in history, localities focused on what was best for their own needs. From a federalism perspective, can you discuss the Dobbs decision and their approach to push this decision to the states as opposed to the federal government?
You want me to do this one first? Okay. So I think that the federalism angle on Dobbs is interesting. I think that look, I think Jennifer is right in terms of that. Even when you have the localities or individuals had a lot more, I think, freedom to decide these kinds of things historically. Individuals had a lot more, I think, freedom to decide these things historically. There wasn't an idea that the state was going to come in and regulate any of these things. So the idea that a state has general police power over these kinds of decisions, I'm not a historian, I don't pretend to be, but would have struck, I think, a lot of the framers as really foreign, even at a state or a local level, to decide that a certain village in Massachusetts was going to decide this, or the state of Massachusetts was going to decide this. I think, the federalism concerns are important. I think that that's something that, in all candor, that there was a period in the court's history when it really got away from some of the core structural norms of the Constitution. And I clerked for Justice Kennedy, and he was a really big believer that those structures themselves advance liberty. And I think that there are a lot of ways in which it's true, but I also think that there are ways in which those trappings can be used to cloak a pursuit of particular policy preferences. And I think that there are those who think that that's what happened in Dobbs, because it was such a departure from the sort of historical framework that the court had used for these kinds of questions in the past.
Thank you.
All right, we're unfortunately out of time. I think panelists may stick around if you want to come and accost them and ask them the question that's burning on your mind. But can you please join me in thanking our panelists today? Next week, those of you who are registered for this event will receive a link to this presentation and a survey to share your thoughts. You're welcome to take that survey now. There's a QR code on your table. We are planning to do this event again next year and the year after that and the year after that. And if you liked something, let us know, because we're just going to do the same thing we did before, probably, unless you told us that was amazing. I'm glad you brought that person. I'm glad you talked about that. And vice versa. If something didn't really resonate with you, please let us know so that our event in the future can be better. You'll also receive a link for the CLE affidavit for Colorado attorneys seeking that credit. And we will be in touch with you with other programming efforts. So thank you very much. Have a great afternoon.